Well, hey there. Welcome in to the first Lunch and Learn in a while. I hope everyone had a summer. I'm not sure if it was a good summer, but a summer nonetheless. We were just talking a minute ago about, normally the reason we took off summer is people were traveling, all this kind of stuff, and it's a little different this year. But we're excited to be back. We're going to give it just another minute or two before we start today's Lunch and Learn. Let some other people trickle in. Few things I'll mention here at the beginning, and you'll hear me mention more than once. If you have a question today, go ahead and put it in the Questions tab, which is in the upper right-hand corner of the screen. That's going to allow you to put it in a place where I can see it. And be able to discuss it along with Mike today. And right next to that is the chat tab. And please let us know you're here. Let us know you can hear us. If you have any trouble or any comments, you can certainly talk to each other. You can do that all in the chat tab. But if you put questions in there, it's going to be hard for me to seek them out. So definitely get those over in the Questions tab. All right. Well, why don't, now that, so we already have a couple little notes, and this is good because we're still waiting a minute to let some more people come in. Sarah in chat asked, is your video on if you're an attendee? No, it's not. This is a webinar platform. And so you will see the materials we're going to provide. You'll see us. But there are capabilities that you can come on stage if you have a question to ask, and we might try that a little bit later on today. So your video is not on, though. No one can see you, not even us right now. And hello to everyone. Thank you all for coming. I'm very excited. So why don't we go ahead and get started? And to start off the bat, I want to introduce Adrienne from the Cedars Union, and she's going to tell us a little bit about what's going on over at CU and some of the news from there.
Hey, thanks, Tom. I'm Adrienne, like Tom said. I'm Managed Marketing and Programming at the Cedars Union. If you're new to us, we're a nonprofit art incubator, so we offer studio space, whether that be private or communal, for artists in the city. And we also do public programming, such as this partnership with Arts Counsel Texas for Lunch and Learn. Like many organizations, most of our programming is virtual at the moment, but we've had some really great webinars through the spring and summer, all which can be accessed on our YouTube channel, which I'll post here in the chat box in a second. And this September, we have some stuff on art education in the virtual classroom. So look at our website and our events and programming tab, and you can see what's coming up. We also are now doing in-person tours of our space again. So we have restrictions around that for the pandemic. It's one-on-one, but you can learn more about that on our website as well and sign up to take a tour. And we just finished a virtual tour that we'll be posting to our Instagram and Facebook later this week. So check it out.
Well, thank you, Adrienne. And we love partnering with Cedars Union on these programs. And so let me tell you a little bit about these programs if you haven't been here before. These are programs put on by Arts Counsel Texas, which is a nonprofit organization started by Michael that seeks to bridge the arts community and the legal community. And so a number of times a year, we'll come in and give a lunch and learn. Of course, back when we were doing it in person, we were doing it at the Cedars Union, which was lovely. But this year, we've transitioned over to this platform. Few things to note if you just came in. Please do put any questions in the Questions tab on the upper right-hand side, and of course you can chat right there. Few things coming up that want to make sure get on your calendars. First, in about a week's time, we're doing our third legal clinic of the year, and registration is open for that right now. That's at the Cedars Union website, right, Adrian?
Mm-hmm.
Okay, great. And that's an opportunity where you can sign up for some one-on-one time with an attorney who will talk to you about the issue that you're facing as an artist, as a creator. We've really enjoyed doing this. We get in one-on-one Zoom calls, and we're able to drill down into some of your specific questions. Now, it is a legal clinic, and so we're not able to write contracts and do all that kind of stuff, but we can talk to you about the general principles that you may be facing. That's on September 16th. Next month, we have the second part of this 3-part copyright adventure that we're starting today. And next month, we're going to talk about fair use. And fair use runs in a couple directions related to artists. One are the artists who want to ensure that people aren't using their work inappropriately. They're not infringing on their copyrights. And then we have a number of artists who use already existing work in their new work. And so you can be on both sides of the fair use issue, and that is all related to copyright, as you're going to hear Michael talk about a little bit today. I would bet we might mention fair use once or twice. That's on October 14th. The following month, on November 11th, we're going to wrap up the copyright trifecta by doing actual live registration of copyrights on the Copyright Office. I'm going to be sharing my screen. We're going to be doing it for real. We are going to be using some images from Michael, some of his photography. And so that's something that's coming up on November 11th. We also have a legal clinic coming up in November. We have a Lunch+Learn coming up in December. And if you want to mark your calendars, remember, Lunch+Learns are always at this time on the second Wednesday of each month. So we hope to see you at the legal clinic here on September 16th and at the next Lunch+Learn on October 14th. And I am going to now introduce Michael Heinlein. And Michael, why don't you introduce yourself and talk a little bit about Arts Counsel, and then take it away.
Well, I'd be happy to, but I think why don't you share a little bit about how you are, because I think that lends a lot of credibility to what we're saying and why they should listen to you.
Yeah, absolutely. Well, I certainly appreciate that. So I was a fine art and commercial photographer for about a decade before I ever went into law. Owned a gallery down in Deep Elm, a photography-based gallery, for a number of years. And the reason I went into law was to work with this community, to work with artists, to work with creators, photographers, on all of these kind of legal and business issues. And so that's why I started my firm, Madry PLLC, based here in Dallas. And that's kind of what we do. We do art law. We do copyright law. And I've been lucky enough in the last number of years to work with some great organizations, especially in the world of copyright law. And we're really looking forward to some things that are coming up this year. I was just named to the board of the Copyright Alliance, a national organization. Very excited about that. And a lot of court cases we're involved in with copyright. And so today and the next 2 months, very excited. This is my favorite thing in the world is copyright. So that's a little bit about my history. Michael?
So I agree. Copyright's a great fun. Like Tom, law was a midlife crisis for me, so to speak. I used to be an art historian. I taught medieval and Northern Renaissance art history at UNT for many years. And then, as I like to say, the only way to get out of academics when I was finished with that was to go back to school. So I went to law school at SMU and graduated, and am now mostly an intellectual property lawyer. So I do a lot of copyright work, but also patents and trademarks at Thompson & Knight. And after having been doing that for a number of years, I started wanting to get back in touch with the arts community. And one of my law partners and I started an art gallery, which we had for several years. And one of the things that I realized and understood is that there many people in the arts community, let's just put it this way, have an understanding about some business and legal issues. And they knew that they didn't understand, and that they really wanted to know better how to conduct their lives and to do better business. And so we started Arts Counsel Texas, which, as Tom said, is an organization that aims to teach artists about legal and business issues, but also not only do most artists not have a tremendous understanding of legal and business issues, but most lawyers don't know the first thing about the art world. And so the other half of what we do is we give presentations at, for instance, the Dallas Bar, where we talk to lawyers about how they can better help y'all and the creative community. And so that's kind of where I come from. And like Tom said, this is one of my favorite presentations. I love copyrights. It's one of the reasons that I went to, when I graduated from law school, one of the things I wanted to do was intellectual property, because copyrights are so integral and so much related to what I used to do in a way to the art world. And so here we go. I'm going to let y'all see the PowerPoint and we'll try to get going.
And while Michael's doing that, let me remind you, because I know we just had a number of people come in. If you have questions about anything we're discussing today, put those up in the questions tab. I'm going to keep a close eye on that. Feel free to chat with each other in the chat tab. We also put up a few poll questions, one about copyright, one about if you've ever visited CU. Definitely feel free to answer those. And Michael, take it away.
All right. So like we've been talking about, this is the first of a 3-part series on copyrights. And basically today, the ultimate goal is to tell you what copyrights are and how you can use them and why they are valuable to you. And I just kind of wanted to start with a hypothetical. Imagine that you're a photographer and you've got a collection of images, and that you make a fairly good business with these things, licensing them and doing whatever you do with them. And you're shopping at Target one day and you see a rack of shirts with one of your images screen printed onto the shirts, and they're selling for $20 each. And Target is making a good bit of money from shirts that have your image on it. When we do this in person, I like to ask people how they would feel and what they would think if this happened to them. And the answers that I usually get are that people are upset. They feel like something has been taken from them, that they don't like that somebody else is making money from their work. They don't like that they didn't get credit for the image, or that they lost some control over the work that they've done. But the most important thing is people are upset because they feel like something has been taken from them. But this is kind of an interesting concept. What is it really that someone has taken from you? If I'm this photographer, I still have that picture. I can still print that picture. I can still sell that picture. I can even decide if I want to screen print it on shirts and sell those shirts myself. So this is an interesting kind of stealing, an interesting kind of theft, where what is it that's been taken from me? I still have everything that I had to start with. And here's a case where the legal community and the government kind of understands that there's something wrong with this. Even if I still have that image, something has been taken from me. And they created, the Congress has created what is called a body of intellectual property law. Intellectual property law. And copyright is an element of intellectual property law. And so what they understand, what the law understands, is that what was taken is not so much the picture itself, but my ability to, somebody took my effort and the work that I put in to create this, and now they're profiting from it. And I guess one of the analogies that I like best here is like a pharmaceutical company that's coming up with a cure for cancer. or like right now, a vaccine for COVID-19. It's costing thousands, millions, billions even of dollars to come up with this cure for cancer, right? Once that company does it, it doesn't want to sell it for 10 cents a pill because it's not going to be able to recoup the $10 billion it spent to create that pill. It needs to make a profit. If it can't make a profit, then there's going to be no incentive. And here's the key: there is no incentive to spend the investment to come up with that in the first place. And so that is kind of the policy reason behind intellectual property law, is that the idea is to incentivize inventors, to incentivize artists to create work. And the way that they do that is prevent other people from taking advantage. And for instance, in the pharmaceutical business, if I'm a company that just came up with this cure, I don't want somebody else taking that without having made their own investment and then selling it for cheap, because then I'm not going to be able to recover that, and I'm not going to invent something the next time. So that kind of is the policy reason of why we protect intellectual property.
I always think of it in terms of an author, and for some reason this just always makes sense in my head. If I spent 9 months writing a novel, and then I publish it on Monday, and on Tuesday someone bought it from me, copied it wholesale, put their name on it, and started selling it right next to mine, that would be pretty terrible, right? And so that goes to the policy that Michael was just talking about, where you have to have some incentive, because why would I ever write a book? If that happened, there would be no point in wasting the 9 months to do it. And so copyright is about that balance, right? About that incentive.
Absolutely. And actually, like I said, it's a form of intellectual property law. And I just want to briefly go through what is the different types of intellectual property law, because in my experience, most lawyers don't know the difference between trademarks, trade secrets, patents, and copyrights. And if most lawyers don't, my guess is that a lot of you are a little bit confused about that as well. So I just want to spend just a couple of minutes here before we go into depth on copyrights to talk about these other forms. These are the 4 basic types of intellectual property law that there are. The first is trademarks. Trademarks protect words, names, goods, symbols. They protect things that identify the sources of products or services. So a trademark identifies the source of a product or a service. So Coca-Cola is a trademark. The shape of a Coca-Cola bottle is trademarked. The swoosh on this tennis shoe, on this running shoe, is trademarked by Nike. Golden arches and the name McDonald's itself is trademarked. And so the point is here, the companies own the trademarks. So Nike owns the trademark and the swoosh. McDonald's owns the golden arches. But the reason that, here back to policy, the reason that we've created this for them, the law has created this for them, is to protect consumers, to protect buyers. So if somebody is driving down the highway, for instance, in the middle of who knows where, it's in the middle of the countryside, and they see a restaurant, and it says McDonald's on it, they know what they're going to get. I mean, you can go anywhere in the world, and that hamburger is going to taste the same because it's a McDonald's hamburger. You don't want to have somebody throwing up a shack, putting their name McDonald's and putting some golden arches on it and selling something that's even worse than a real McDonald's. So the point is, with a trademark, it's identify the source. You know what you're getting. You know that this running shoe is going to have certain quality because it's got Nike's name on it. You know that the Coke is going to taste like Coke. So that's what trademarks do. Trademarks identify the source. Trade secrets. Another type of intellectual property is trade secret law. A trade secret is some kind of information that a competitor, so it's something that a business would have. It's information that a competitor could make money with if the competitor had it. But the competitor doesn't have it because you, as the trade secret owner, are keeping it secret. So again, a trade secret is information that another company could use to make money if it had it. But because you are keeping it secret, they don't. And as long as you're keeping it secret, if they take it from you, then they have stolen your trade secret, and then they're liable for that, and they get in big trouble. Now, the thing about the trade secrets are powerful because they can last forever. But they don't stop you from, they can't stop somebody from figuring out how to do it themselves. So for instance, the picture here is the vault where Coca-Cola supposedly keeps the secret recipe for Coca-Cola. If another company figured out how to make cola that tasted like Coke and actually used the same recipe, but didn't steal it from this vault, Coca-Cola could not stop them from doing that. If somebody else figured out Colonel Sanders' secret recipe, then Kentucky Fried Chicken, KFC, I guess they're called now, couldn't stop them from doing it. They can only stop them from doing it if they actually stole it from the vault, or if they somehow stole it from KFC. So trade secrets last forever, but they don't prevent reverse engineering, is the term. You can reverse engineer it. We also have patents, two types of patents. The first is a utility patent. Patent law is intellectual property. People normally understand it as intellectual property for inventors. Patents protect something that is new, and here in bold, this most important, is useful and not obvious. So if you're the first person to come up with something that is new, useful, and not obvious, you can apply for and hopefully get a patent on it. And so what you're looking at is an example of a United States patent for a new and useful type of artist easel. Patents are kind of like trade secrets in that if they're therefore typically for something that's useful, the trade secret is. Patents are always something that's useful. And if you have a patent, you can prevent anybody else from making, using, or selling that particular invention. So if I had the patent in this easel, I could stop the rest of the world from making this easel. I'm the only one that's allowed to make it and sell it. Unlike trade secrets, though, it is only good for 20 years. And it's only good for 20 years. So big difference. Let me back up. Big difference between the trade secret and the patent is that you cannot, nobody can even reverse engineer this easel. If you figured out how to do this and you weren't copying me, I could still stop you from doing it because it's a patent. It's not just a trade secret. Because it's so powerful, because you're not even allowed to reverse engineer it, it's only good for 20 years. And it's only good if I tell you how to do it. So the whole point of this patent is this piece of paper here, and it's got 20 or 30 pages usually. The other pages behind this tell you how to do it. So the key of a patent is it's teaching you how to make the invention, but in exchange for me teaching you how to do it, you are not allowed to do it. I get the monopoly on it for 20 years. Utility patents, like I said, are for useful objects. Design patents are kind of interesting, and I think a lot of creatives and artists are interested in design patents because design patents protect the design of useful objects. The design of useful objects, and here this is going to be key when we talk about copyrights in just a minute. They only apply to useful objects. A useful object is something like a piece of furniture, or a container, or a car, or clothing, something that you actually use to do something else. If you come up with a way of making that useful object that looks different in some aspect from all other of the same kind of object that have ever been made, then you can apply for and get a design patent on that would prevent anybody else from ever doing it. Well, for doing it for a number of years. So the reason I have a picture of a design patent of a shoe is that for some reason, typically shoes, maybe more than any other type of object, tend to get these design patents. And so this is for 14 years, a design patent is only good for 14 years, but for 14 years, no other shoe company can make a shoe that looks like this. They can make shoes that look almost like this, but if they look just like this shoe, the one that is pictured in the patent, then then the patent owner can stop them from doing it.
Michael,
yeah.
We had a question, and it's stepping back one moment to trade secrets. The question was, are trade secrets enforced globally?
Trade secrets are, well, that's kind of a interesting question, but trade secrets are protected within Texas. So they're not protected globally. No, it's just within the United States. And so if I have a Texas trade secret and somebody is doing it in California, I could stop them from doing it in California. And typically, though, it's typically, and I'm talking about in my experience, most trade secrets are something that is fairly local. So if I'm a business in Texas, most likely it is going to be a competitor that is someplace in Texas that has stolen my trade secret and is using it. If we're talking about Coca-Cola, Coca-Cola could not stop a Chinese company if a Chinese company came in and stole the trade secret from the vault in Georgia. It's also, there's criminal trade secret statutes. And so if that company ended up coming to the United States, they could be arrested and charged with that in the United States. But typically the trade secret isn't going to stop a Chinese or a French company or whatever from using the trade secret if they somehow manage to steal it. No.
Yeah, absolutely. And we had one other question here, and I'm going to, since it ties in, gets us back to design patents. And Robin asks, what is the degree of variation needed to make your idea different from an existing patented idea?
So that is another interesting question, and we're going to talk about that in more detail with copyrights, but it's fairly close to the same notion. It just has to be a little bit different. But if it's only a little bit different, it is not a very strong patent, because that somebody would have, it's very easy to change that little different and make it so it looks like it, but it isn't quite the same. So you could get a patent in a very tiny difference, but it's pretty expensive. It costs $4,000 or $5,000 to get a design patent. It takes 2 years of your life typically to get it. And it's probably not worth the time and the expense to do it for just a small difference. But and actually, like I said, we're going to talk about that in just a few minutes with respect to copyrights. And so you can channel back and look at what I say about that to your question here about, I think I'll answer in more detail about copyrights. Speaking of which, let's now turn to copyright. So that's just a very, very broad overview of the other types of intellectual property law. Turning to copyrights, I think Tom mentioned this at the outset. Typically, there are two big questions that I found that creatives have about copyrights. First is, how can they be used to protect your images? How can you use a copyright to protect your image? Part of that is, what is a copyright and how can it be used to protect your images? So this person that walked in and found his image on a t-shirt, how can copyright help him? The second is what we're going to be talking about next month. What can I take from somebody else's work, for instance? If I see a photograph of Prince and I want to make a painting of it, am I allowed to do that? And if I am, how much of that can I take? And so that's a question of fair use. And we're going to talk about fair use in a lot more detail next month. So again, what we're going to talk about today is, what do copyrights protect? How do you get them? And how can you use them? And then as part of how can you use them, I'm going to talk a little bit about why you need to register them. We're going to talk about the process of registration in 2 months. But today I want to spend just a little bit of time at the end talking about why you need to do it. So that's coming up today too. So what do they protect? Copyrights protect original works of authorship fixed in a tangible medium. real great legalese right there. What the heck does that mean? Original works of authorship fixed in a tangible medium. I think this is why not just creatives, most people hate lawyers. We talk in this stupid language like this. So let's talk a little bit about what all this means. First of all, original. Like I said, in answering that question, it doesn't have to be very original. I'm starting with something that is not, this just to give you a little background. The image on the left is the original statue of David by Michelangelo. The image on the right is about as an exact a copy as can be made. The reason that they made that is because the original used to be outside and it was getting worn away and eroded and corroded by weather. And so they wanted to move it inside, which is what you see on the left, but they wanted to continue to have at least a replica of that image to maintain the appearance on the outside. And so they hired an artist to do a quote, exact unquote copy of that original. The artist who made the copy, the artist who made the one on the right, is likely not going to have any copyright at all in that image, in that statue, because it is not different. It is not original at all. But let me show you another example. This is another copy of Michelangelo's David. This is by an artist named Hans Peter Feldman. It was done in 2006. This is in Cologne, Germany. And you can see that this is not an exact copy. There's some paint. There is the articulation of the muscles and the shape. I mean, the skin is a little bit different. You can tell that it's clearly there's a difference. One is not an exact copy of the other. Hans Peter Feldman can get a copyright, and in fact does have a copyright in his image on the right, to the extent that it is different from the one on the left. So that doesn't stop somebody else from making another copy of Michelangelo's, but it would stop them from making a copy of Michelangelo's David that looks like Hans Peter Feldman's. And now I've been talking kind of hypothetically. There's actually a really interesting case that came out fairly recently that goes exactly to this issue of originality. The upper left is the Statue of Liberty in New York. The lower right is the Statue of Liberty in Las Vegas. Clearly, the one on the right is a copy of the original by a sculptor named Robert Davidson. In 2012, Davidson realized that the United States Post Office had minted a stamp with an image of the face of the Statue of Liberty on it. And that is at the top of this stamp. And Davidson looked at that and realized that the image on the stamp is a copy of his Las Vegas statue, not a copy of the original Statue of Liberty in New York. And so he sued. And believe it or not, well, he sued. The post office said, no. You can't have a copyright in that. That's just, there's nothing original about it. Davidson said, though, that there were meaningful and non-trivial differences between his Las Vegas Statue of Liberty and the original. And to quote him, he said, I just thought it needed a little more modern, a little more contemporary fact, definitely more feminine. He wanted his to look more feminine. He said he wanted the face to look fresher, a little bit sultry, and he described it as a bit sexier, so it was more appropriate for Las Vegas. The hair is different, as you can see. The eyes and lips are a little bit more sharply defined. The skin is a bit softer. Again, these are, I would have to say, these are fairly subtle differences, but the court and the jury ended up agreeing with Davidson and awarded him over $4 million in copyright damages because the post office had copied his statue, his image, and not the one in New York. And that's just to give you some sense of how original it has to be. It doesn't have to be very original, just a little bit of a difference over something that's ever been done before. The next requirement, well, the third requirement actually, is that it has to be fixed in a tangible medium. And that means, it's kind of nebulous, but that means you can't just say something or do something. If you are a musician, for instance, and you're playing a cello in the subway, and you're playing a song that you just made up, that nobody has ever played before, that nobody has ever heard before, and it's a beautiful song, and you're playing it, and you're not recording it, there is no copyright in it. You have no copyright in that song because it is not recorded. If I am talking to you right now, and I am saying words that have never been said before in a pattern or something new that's never been said, and this is not being recorded, my words are not copyrighted. If they are being recorded, and if the musician is recording his or her piece, there's a copyright in it. So that fixed in a tangible medium just means it has to be recorded somehow, in some form. It could be a photograph, it could be written, it could be on a CD, on a DVD, whatever. So long as it is recorded in a tangible medium, then it can have a copyright. The third requirement is that it has to be a work of authorship. So this is the first real issue. What is a work of authorship? What kinds of things are protected? This is defined by the copyright statute. The copyright statute says that you can get a work of authorship is a literary work. So a poem, a novel, actually computer software, something that is written is a literary work is a work of authorship. Musical works are works of authorship. Dramatic works, pantomimes, choreography, motion pictures, and sound recordings. All of these things are works of authorship. But what matters for y'all, I'm sure, is that works of authorship include pictorial, graphic, and sculptural works. Pictorial, graphic, and sculptural works are works of authorship that are protected by copyright. Interestingly, in the 1990s, this wasn't always the case, but in the 1990s, architecture is now protectable, is now a work of authorship that is protected by copyright. What is architecture is kind of interesting. To be architecture that is protected by copyright, a building has to be, and here's more great legalese, a humanly habitable structure that is intended to be both permanent and stationary. Humanly habitable structure that's intended to be both permanent and stationary. So a building like the Playhouse here can be copyrighted and is copyrighted, but a bridge, a beautiful bridge like the bridge downtown over the Trinity River, cannot be copyrighted because it's a work of architecture that is not humanly habitable. But for our purposes, I think for most of y'all purposes, if it is a pictorial, graphic, or sculptural work, it is a work of authorship that if it's fixed in a tangible medium and is original, can be copyrighted. What cannot be copyrighted, and here's some things that are probably going to frustrate some of you. Copyright does not protect utilitarian works. A utilitarian work, such as a teapot, it's something that you use, can't get a copyright in it. Copyright does not protect words and phrases like just do it or lather, rinse, repeat. These things, if they're protectable at all, are protected as trademarks, like we talked about a little bit earlier. Trademark doesn't protect facts. So if the Rangers play a baseball game last night and the score, I should have looked it up to find out what the score was if they really played, but if the score was 6-4 and they won, if you are the first person to report that score, you can't have a copyright in it because that's a fact. You cannot copyright facts. You can copyright the way that you tell those facts, the words that you use to describe them, but the facts themselves are not copyrightable. Here's a couple of examples that are one of the reasons that copyright law is so remarkable. This is a work of sculpture by Gail Lawson from 2005. It is a human torso, male torso, nude male torso. And from what I've just described, I think that this is a sculptural work. It's a work of authorship. It is fixed in a tangible medium. And I can tell you that this is original. There was before this nothing that looked exactly like that. So this can have a copyright, yes. What about this right here? Let's just describe it first. This also is a nude male torso. It's fixed in a tangible medium. It looks like a sculptural work, but is it copyrightable? And the answer here is no, because this is a mannequin, which means it is a useful object. It is something that is used to hang clothes. This is, and there is no other, no other legitimate difference between the work on the right and the work on the left, other than maybe quality, to distinguish it. But because it is a useful thing, courts have held that mannequins do not get copyright protection. For the same reason, clothing is a useful article. Serves the utilitarian function of dressing the human form. Therefore, Congress and the courts have said that clothing design does not get copyright protection, no matter how new or unusual or different it is from anything that ever came before. If you need to get intellectual property protection for a new design for clothing, you would have to get it as in the form of a design patent. And what's frustrating about that is not only is it expensive, but how long do clothes stay in fashion? If it takes 2 years to get your design patent and you can't stop anybody from doing it for 2 years until you get it, this is not going to be, nobody's going to be wearing it after 2 years because fashion is so ephemeral. It's good for, a couple of weeks or months at best. And so you don't see very many design patents for clothing other than shoes. And for some reason, shoes are an exception to that.
Michael, can I jump in real quick? So one good question that came in, and I think this applies not only to the picture of the mannequin, but all the examples. And it says, but this photograph of the mannequin is copyrightable, yes?
Absolutely, the photograph is. Yes.
And so the photograph of the model, wearing the clothes is something you can copyright. And even though the actual items that Michael's discussing may not rise to being able to obtain copyright protection themselves, the photographs that you create in almost all circumstances, and there are a few exceptions, but almost all circumstances will be copyrightable subject matter.
Exactly. I mean, the photograph itself is a work of authorship. It's a pictorial work of authorship. If nobody has ever made a photograph that looks like that, and it's original, and it is actually printed or stored in your camera as pixels. I mean, as in the software of your camera, then it is itself copyrightable. I mean, you can take pictures of all kinds of things that can't have a copyright. I can take a picture of a tree. There's no way that tree has a copyright, but my picture of the tree, my photograph of it is definitely copyrightable, yes. Interesting about this dress, cannot get a copyright in the dress, but you can get a copyright in designs printed on the dress. So the question is, can you separate the function from the design? Copyright protects the aesthetic elements of a useful article if those elements are works of art that can be identified separately from and exist independently of the dress. So in this case, you can imagine that this picture of the little cherub and the flowers and the plants can exist independent of the dress. So this image that is imprinted on the dress, that is copyrightable. It's just the form of the dress itself that is not. So if I paint a picture of some kind of a flaming something on the side of my van, the van is not copyrightable, but the picture that is painted on it is, because I can separate aesthetically the form of the image from the function of the car. This is like one of the things I love the question of, so if you have, I said you can't copyright a teapot because it's functional. What if I'm a ceramicist and I make a solid object that looks like a teapot and it has no function? I think arguably, I've not seen this case, but I think arguably you should be able to get a copyright in that object, even though it looks just like a teapot, because it's not. I could copyright that shape, but I couldn't stop somebody else from making a teapot that looks like it. So it's a little bit of weird law.
Michael, we have a few questions. Do you want to jump on them now? Do you want to move on a little bit? Okay. So one question, well, what about wearable sculpture, jewelry, and art? Is that something that's going to be subject to copyright?
So that's a slide that I thought about putting in here, but I didn't. Jewelry is going to be subject to copyright because jewelry, the function of jewelry is to decorate. And so jewelry works. Sometimes there's a question if it's a belt buckle. There are cases about belt buckles, for example. The question there is the shape that you made the belt buckle something that is separate from the function of the belt buckle? And there you get people arguing both sides. The slide that I didn't include, there are cases that have held that, like Halloween costumes, cases have held that because they're just like clothes, they're not copyrightable. I mean, maybe the pictures on them are, but the costumes themselves are not. But there's a great case that there's a company that made animal nose masks. So a pig nose, people have probably seen those. You wear a pig nose on your face or an elephant nose. The court said that there's no function of being carried out by that. So you can copyright the elephant nose mask, even though you can't copyright the elephant costume. I mean, the law is pretty weird and funny.
And following up on something you just mentioned, what about the pattern for the textile? Is that allowed to have a copyright?
The pattern for the textile, the pattern itself. I think the pattern is, and and the reason I'm going to say that is that I mentioned that only in the 1990s did architecture start becoming copyrightable. Before that, if you were an architect and you designed a building, somebody could come and look at your building and make an exact copy of it, and that was okay because in 1980, architecture did not have a copyright. But the blueprint for that building was copyrightable as a pictorial work. And so if you were the architect and you were able to prove that somebody copied the blueprint and then used that to make their building, then they did infringe your copyright in the blueprint. And I would say, based on that kind of an argument, that the template for the dress, the pattern for the dress itself would be, if you could prove that somebody copied the pattern.
I think, and you read that, I think, in the way that is accurate. And when I heard pattern, I was thinking graphic, the graphic design that ended up on I think in both ways they would be copyrightable.
Yes.
One more here, and I'll probably jump in and answer this one since it's going to tie into something we'll talk about soon. The question is a copyright inherent in any or every original artwork? Therefore, it belongs to the creator legally, whether you have applied for it or not. And this goes back a little to what Michael was saying, but the short answer is that if you have an original work of authorship that's fixed in a tangible medium of expression, then you have a copyright at the moment of creation. If you have been making little doodles here during the webinar, you likely have a copyright automatically in those. What I tell my photographers is the minute you press that shutter, you've now fixed your original work in a tangible medium, and you own that copyright. You don't have to do anything else to own your copyright. You own it. You don't have to tell anyone. You don't have to do anything. But if you want the absolute full protection of the law, including the ability to take someone to court if they infringe, then you have to register your copyright. And of course, registration is something we're going to be talking about here in 2 more Lunch and Learns, where we're going to dive deep into it. The short answer, though, is that registration is not a required step to own your copyright. You own it at the moment of creation, as long as all those other things are fulfilled. Now, what is the bar? In your question, you say, is a copyright inherent in every original artwork? No, but I would say the bar is pretty low for that kind of originality, creativity type argument. It's very rare that we run, for example, into a photograph that is not copyrightable because of the subject matter. And Michael, I think next month I'll be bringing up a few things related to that, and Michael has a few real good things on that. So the short answer is no. The long answer is yes, and that is a very lawyer answer. So I'll stop there.
All right. So moving on to what is a copyright and what is not. Copyright does not cover. You cannot get a copyright in an idea. You can only get a copyright in the way that you express that idea, and that's kind of hard to understand. So what I typically use is this image of still lifes of quinces. These are 4 paintings that are still lifes of quinces. If you were the very first person ever to make a painting, you had the idea, I could take some color and a brush and put it on a canvas and make this image. That's an idea. You can't stop somebody else from, copyright will not stop somebody else from making a painting. That's just an idea. All right, so the idea of a painting is out there. Other people have done that. I'm going to be the first person ever to do a still life. Can I stop other people from doing still lives? No, because that's just an idea. It's not the expression of an idea. Still life is an idea. Well, how about still life with fruit? Nobody's ever done that. Well, it's still an idea. A still life with quinces. Still, if you were the first person to come up with still life with quinces, you cannot stop somebody else from doing it. So none of these pictures right here are infringing the copyright of any of the other pictures here. What you can do, all you can do is you can stop somebody from making a still life here of a quince that looks like the same picture that I already did. The way that you made that still life of quinces is the expression of that idea, and that's what's predictable. You have a monopoly on the composition, the lighting, the colors, the way that you arrange it, the way that you did it, the way that you expressed that particular idea is copyrightable, but not the idea itself. And that's kind of a complex idea, but the key thing is that you don't get a copyright in just the concept. You get an idea in the way that you have expressed the concept. All right, so that's what copyrights are. Let's talk about a couple, some practical issues. And Tom just answered the first one, which is how you get them. And as he said, y'all have thousands of copyrights right now, whether you've registered them or not, whether you know it or not. Every single person that's listening to this webinar has thousands and thousands of copyrights. Probably invariably, the vast majority of those are worthless. Some of them probably are not, but regardless of their value, y'all have lots and lots of copyrights. And for works that were created after 1978, that copyright protection, as Tom said, begins at the moment the work was created, and it lasts for, if it's yours, it's going to last for your entire life plus 70 years. So copyrights last for the life of the author plus 70 years. For things that were made before 1978, we could spend an entire hour talking about that because it's a lot more complicated. But Congress in 1978 made copyright ownership really a simple concept. As soon as it's created, you have a copyright and your heirs have a copyright to have the same copyright for 70 years after you die. The only exception to that is, the only exceptions to that are works for hire. A work for hire is a work that is created by an employee as part of his or her job. So if you are the graphic artist working for Walt Disney and you make an image of Donald Duck, you do not own the copyright in Donald Duck. Walt Disney does, your employer does. You might, another type of a work made for hire, as opposed to an employer and employee, is if you're a contractor, if you're an independent contractor, and you're making a very specific type of work, and there's only 9 kinds of work that this applies to, and in your agreement and in your contract of employment, it says that you're making work for hire, then the person that hired you as an independent contractor can have the copyright in that. But there are so few examples of cases where of the types of work that applies to, that's just not something that most of y'all are going to run into. Really, the key work for hire situation is where you're an employee and you're doing it as part of your job as an employee, then the employer owns the copyright. And I think that what's important here is that if you are commissioned to do a piece, so if somebody hires you to make a sculpture, if you're an architect and somebody hires you to design their house, even if you're a sculptor or a painter and they tell you, I want this thing to look abstract, I want it to have these colors in it, I want it to have 4 people, regardless of how much they tell you and how much input they have into what they want this work to look like, you have the copyright in it. They don't. So if all it is a matter of you being commissioned to do something, you have the copyright, they don't. So what can you do with it? So now we know how you got it. What can you do with it? If you have the copyright, you own this copyright, it allows you, it means that you have the exclusive right, you have a monopoly, you have the exclusive right to make copies of the work, to adapt it into another medium, and I'll talk about that in just a minute, to distribute copies or adaptations of the work, to display it remotely, for instance, on the internet. You are the only one that's allowed to do these things. Anybody else does it without a license, without you telling them that they're allowed to, they're infringing your copyright. We'll talk more about infringement in just a minute, but we can talk a little bit about transfer also. You own this copyright. Can somebody else take it from you? How do they get your copyright? Well, the only way somebody can get your copyright is if you very self-consciously give it to them. Either you give it to them or you give them a license to it. And this is another thing that changed with the law in 1978. If a copyright owner sells a physical object, sells the painting, for instance, this is a painting of the quinces that was one of the 4 quinces earlier. This is a painting that is, I guess I can't see it from here, but it's down the hall in my house. When the artist sold this to me, I got the painting. I did not get the copyright. When you as an artist sell your work, you still have the copyright in that work. That's really important. Before 1978, there was a lot of question about this. Before 1978, it was probably likely that if you sold the work, the person who bought it got the copyright and the work, but that's not true anymore. So that means that when I got this work, I could hang it, I could put it in storage, I could do almost anything I want with it, but I can't do any of these things with it, right? I am not supposed to make copies of it, adapt into another medium, distribute copies or adaptations or display it remotely because I don't own the copyright. Michael Moore, actually his name is actually Michael Moore, owns the copyright, and so those are his rights. Now, as an artist, you can sell me the copyright, but that has to be in writing, and you're probably going to want to charge me a whole lot more for it because the copyright is valuable. Or you can give me a license. You could license somebody to be allowed, which is to say you can allow them to do any of these 4 things. So let's say that I have this picture of Michael Moore and I want to make a t-shirt out of that. He could have given me a license that said, you are allowed to use this image, to put it on coffee mugs or to put it on a t-shirt, in which case I would be allowed to do that. But I can't do that unless he gives me the license. So without a license, as I said, the copyright owner, as I just said, has the exclusive right to do those things. And if somebody else does it, if Target is selling an image with a shirt with my image on it, they're infringing. Just a couple of cases, just as actual examples, as opposed to my hypothetical of the t-shirt. This is a photographer named Daniel Morrill in 2011 took a bunch of pictures of the earthquake in Haiti in 2010, took pictures of the earthquake in Haiti and posted them on Twitter. And after he posted them on Twitter, Getty Images and a company called Agence France Presse took them from Twitter, made copies of his images, and then basically sold them to newspapers around the world. And within days, they were being published and printed throughout the world in newspapers without Daniel Morrill's permission. He sued. Agence France Presse and Getty Images said that he gave us a license to do it. He put it on Twitter. If it's out there on Twitter, anybody can copy it. We could retweet it. We get to have it. It's on the internet. It's ours. The court disagreed and held that just because you can retweet it doesn't mean you can copy it and put it into a different medium like this and put it in some kind of a different venue. Just because it's on the internet doesn't mean it's in the public domain. And Morrill won over $1 million from them. So you cannot copy. That's one of the most obvious kinds of infringement. A little bit less obvious is when I talked about adapting it into another medium. I have a couple examples of that. A real famous example is Jeff Koons, who at an airport someplace found a postcard that had the photo that's the image on the left. It was a photograph by Art Rogers called Puppies. Jeff Koons loved this, made 3 images that looked just like the one on the right called String of Puppies, sold them for, actually, if I recall, over $100,000 each. And Art Rogers found out and sued and actually won because one of the rights that a copyright holder has is the right to adapt the image or adapt the work into another form. So, for instance, you can't make a movie out of a book without the author's permission. You can't make a sculpture out of a photograph without the photographer's permission. Goes both ways, though. Not only can a sculpture not make a sculpture out of the photograph. Here's another example of the post office screwing up. This is a fairly recent case where what you see on the left is a photograph of the Korean War Memorial in Washington, D.C. And it's a photograph of that. The post office loved the photograph and wanted to make a stamp that was ultimately based on it and did that. And that's the stamp that you see right there. The sculptor in this case sued both the photographer and the post office and ended up settling with the photographer and taking the post office to court, and ended up here again, winning, actually in this case, several $100,000 from the post office. So it's another example if you cannot adapt the original work, the copyrighted original work of authorship into a different format. This actually, if there are no questions about this, I'd be surprised, because this is actually something that's rather scary. So what does that mean? If I'm going to the park and I'm taking pictures of sculpture in the park, does that mean I'm infringing people's works? Well, here's where copyright is kind of interesting for lawyers, but not for anybody else, because it's very much a gray area. Here, I would say it depends on how, and this is a little bit touching on the fair use that Tom's going to be talking about next month, but you're going to have to argue that it's really a picture of the landscape and the sculpture just happens to be part of that, if you want to get away with that. But if you are taking a picture of the sculpture and that is the subject matter of your image, then I think that you're going to be have a lot harder time arguing that you are not infringing the work of the sculpture. That's different in just about every other country that I'm aware of. If you're in Australia or France, if there's a sculpture that is on public display and it can be seen from the street or it can be seen from the park, you can take a picture of it and that's okay.
And one of the things we're going to be looking at, not only in fair use, which is kind of when that kind of infringement is okay, and in registration. When you register a work, one of the questions the application asks for is, are you using any copyrighted work within this work? And it doesn't say you can't. It simply says that by saying yes, you're excluding the parts of your work that are already copyrighted by someone else. So what then you have is a copyright on everything but the thing. Now, if you're taking a picture of a sculpture and the whole picture is a sculpture and the only part that's not is, a little bit of background that you can't see anything in, that may not be eligible for copyright protection in and of itself, right? So you can see how this can get a touch complex.
Right, which is why I say lawyers like it maybe more than y'all.
Yeah. I have a few questions, Mike, if you want to. So one question from Lori. She says, do I have to include, quote, the artist retains the copyright in a sales contract?
You don't have to, but it's a good idea to do that. One of the, and I always, when I'm writing contracts for people, I put that in the contract because that makes it absolutely clear that, okay, so let's take another hypothetical. We love hypotheticals. You sell a painting to somebody because they love it, and then you find out that they have made a Christmas card out of that, or they put it on their Facebook page, and you don't, by putting it on their Facebook page, they are infringing your copyright to display it remotely and to make a copy of it, both. And if you wanted to sue them, yes, they've clearly infringed. But as I'm going to explain in a minute, one of the ways that you can get more money and be more successful, how about that, in your lawsuit, is to prove that it was a willful infringement. And if they, in their contract, agreed that they understood that you retained the contract, then that is going to be a lot easier to prove that it was a willful infringement, that they knew they were doing something wrong. But you don't have to, because regardless, it's yours, even if you didn't put that.
Another quick question here. So the post office can make a stamp of any photo, and others can use any way they want from a photo from a photographer that's been dead for more than 70 years? And I think maybe, Michael, why don't I ask the question this way? What happens after 70 years expires and the copyright runs out? Can you renew copyrights? What's the deal?
So I'm going to try to answer this the easiest way possible. Let's for the sake of this question, I'm going to assume that the original picture was created after 1978. And if it was done after 1978, and let's say the picture was made in 1980, and the artist, the creator, died in 2000. In 2070, the copyright is gone. It cannot be renewed. There's nothing left of it. It is in the public domain. And if 70 years after the death of the artist, if the work was created after 1978, then anybody is free to use it. And the reason that I am stressing this 1978 is that there are some weird possibilities that are like 0.5% or less potential that they'd ever happen. But there is the possibility that the copyright in something that was made before that could still exist years after somebody died. But this it's pretty impossible.
So I'm going to knock through a couple more quick questions, and then how much more do you have, Michael? Quite a bit.
10. Well, no, I can get done in 10 minutes.
Okay, cool. Let's answer a few more.
And it's assuming we usually keep this going until 12:30. So 1:30. So we're good.
Okay, cool. I think this is a great question. If a client sends an image they took and asks for a commission painting from it, who holds the copyright?
Say it one more time so I can get it straight.
If a client sends an image and asks for a commission painting from it, so I send you an image that I took and I say, please make me a painting, who holds the copyright?
I think that's interesting. So I think that what that person essentially did is give you a license to make an adaptation of it. And so you have the copyright, well, the commissioner who made the picture that is being copied, right? Commissioner retains the copyright in the original work, and therefore, to the extent that original work is part of the adaptation, has a share in the copyright in the adaptation. But you, having been licensed to make that, have the copyright now you do have a copyright in the new work. It's what I would argue.
And I go generally a little bit further on some of these issues than Michael may. If you're making a painting of something and you're using a work more for inspiration than some kind of direct copy, then I think that's probably you own the copyright in the painting and the commissioner owns the copyright in the original photo. And that leads into another question, which is before you said that a photo in which a mannequin was the main subject was copyrightable, even though the mannequin is not. So why wouldn't that apply to the statue and a landscape image, even if the statue isn't copyrightable? I have an answer, but Michael, do you want to opine at all?
Wouldn't that apply to the statue?
Yeah.
Well, the statue is not according to the statute and according to the Congress, the statue itself is not a functional object. You don't use the statue to hang clothes on or to do anything. The statue is purely there for its visual effect.
So if you take a photograph of something that cannot possibly have a copyright, then you can't infringe on that thing that has a copyright. Now, going along the path of my last answer, I would say this. I have made and do believe in real strong arguments about photographs of things, even things that are copyrighted, having their own copyrights because of all the various things that photographers do to create the image. I think in general, I'm more expansive in my view of what is entitled to discrete copyright protection. But this goes back to exactly what Michael was talking about, which is the reason lawyers love this is because lawyers don't know and can't agree on where these lines are for things, right? It's kind of like, you know when it's egregious and you know when it's not a problem at all. And everything in the middle kind of can go either way. We're going to see a lot of that when we start talking about fair use next week. But to answer the question directly, a picture of something that could not be subject to copyright protection can never be infringing upon the thing because there isn't a copyright attached to it. Okay, why don't you keep going, and we have 2 or 3 more. Let's answer this one real quick because this is a quick one. I'll let you answer it, Michael. Isn't there a rule that if you modify an original image by X%, you're no longer violating a copyright?
So Tom is going to talk a lot about this more next month, but the short answer is no, there's no such rule. People have heard this. It's like an old wives' tale, the 10% rule. If what you copied, if the most important part of the image that you copied is only 10% of that image, then you're still infringing. You could take it. Let me go back to this picture of the quince. The actual painting of the quince is a very small proportion of that painting. But I think there's a good argument that if all I copied was one of those quinces, and it's an exact copy of those quinces, that's, even if it's 10%, that's a copy. If I copied 50% or 75% of this picture, and it happens to be the upper portion of the picture and everything but the lower left corner, that is a huge part of the picture, but that's hard. I'd have a hard time arguing that that would be an infringement because it's not the most important part of the picture. So it depends on how important the piece that you've taken is.
Good deal. All right, why don't you finish up there, Michael, and we might have 1 or 2 more at the end. We are going to have to. I have to duck out right at 1:30,
Well, I can do this pretty quickly.
Okay, go for it.
So let's say now that you found out that somebody has taken your work, they've infringed it. What do you do? How can you stop this from happening? We have and we can spend entire Lunch and Learns on this. So I just want to go through the high points again. The trouble is that there is not that much most people can do for a number of reasons. I would say that the first thing to do, and Tom will talk about this, I'm sure, at some point, is to write a letter to the person that actually took it. Because if you do this properly, and if you get a lawyer to do it, and it's not combative, and it's just saying that I understand that you took this, maybe you didn't realize it, but this is mine. I normally charge this as a license fee, and I would expect something along those lines. I don't know what percentage of the time, but that is probably your best bet in terms of being able to come out ahead on this. Unfortunately, a lot of times those kind of letters are going to be ignored, or if not ignored, you're going to get a reply that says, forget it, we're going to continue to use it. And if that happens, then you're kind of in a pickle, because what have you lost? You've lost potentially license fees. You've lost control over your image. You could sue them. But the trouble is that most lawsuits for copyrights, the last time I looked at, the average was $350,000 for a successful copyright lawsuit. Let's say that you succeed. You just spent $350,000 and you get back what you lost, which was your license fees. And so maybe that's $1,000. You just pay $349,000 to win $1,000. That unfortunately is why so often creatives, photographers, painters, copyrights are taken and they can't really be enforced. They can't do anything about it. Fortunately, there are some things that you can do to help mitigate that and to make it easier for yourself to be able to recover, and to make it more difficult for somebody to just get away scot-free. And I'm kind of doing this, and I probably should have done this in a different order, but the first thing is there's no law that says you have to put copyright notice on your works, but Tom and I think, both recommend that everybody puts a little C on there, copyright notice. It could be this kind of a C. It could just say copyright. It would include the year that it was first put out there in public and your name. Now, you don't have to do that. You have the copyright even if you didn't do that. But the reason that we advise it is that to get the maximum amount of something called statutory damages, which I'm about to tell you what they are, you have to prove that the infringement was willful. And if you marked your work with the copyright symbol and the date and your name, then there's a presumption that anybody who copied it did it willfully, and you can get the most possible in what are called statutory damages. The other thing that you can do, so we recommend that if there's any work that you want to protect, you put this notice on it. Yes.
Oh no, I'm going to put on mute for a second. I have someone here in the office, and so I'll be right back.
All right. So the next thing is, even though you don't have to do it, I think Tom said this, you don't have to, you have your copyright. We absolutely recommend that if there's any work that you want, that you're worried about that might be stolen, or that you want to be sure that it's protected, that you should register it. First of all, you cannot sue anybody until it's registered. So let's say you're out there and you see that shirt in the Target and you want to sue them. If you haven't already registered it, you have to go and register it, because you're not allowed to bring a suit unless you've registered. But like I said, if that's what you did, all you're going to be able to get back is your monetary damages, which are typically a license fee. And so you're not going to be able to afford to do that. But if you registered it before the infringement, so if you walked into Target, you saw that it was being used, and you had registered that picture before they infringed, then you can get something called statutory damages. Statutory damages means that you can get between $30,000 and $150,000 for each infringed work, and you're likely to get back your attorney's fees. So let's say that you're the person in the Target that's found your work in the Target, and you sue and you win. And it was just that one example. So all they did was they took that one picture and they made a set of clothes with it. You get $150,000 if you had it marked, because it was clearly willful, and you get your attorney's fees back. So you get $150,000 plus the $350,000 in attorney's fees. That all of a sudden means that you're able to both financially and you have an incentive to enforce your copyright. But again, to do that, you need to have registered it first, and hopefully to have marked it so you can get the willfulness finding. Like Tom said, we will be talking in more detail and going through and showing you how to register it. It is a very simple process. It's pretty inexpensive. Everybody watching now can easily afford it, and we're going to learn how to do that in 2 months. And hopefully what I just described is enough to incentivize you to come back in 2 months and to watch, because it is entirely worth the effort for you all to take to register your works. Even though they're copyrighted, you're going to need to register them to be able to enforce them and to be able to afford to enforce them. How about that? And then the last thing I want to do is a teaser for next month, and just to ask you, have I been infringing every time I show this image? We're going to find out next month.
Well, thank you all. Thank you, Michael. Thank you all for coming today and asking those great questions. I think we're going to wrap up here. Let's see, Adrian, any parting words?
Let me give y'all the Cedars Union YouTube channel.
Oh yeah, all right.
I forgot to do that earlier. Sorry. Or maybe not. I'll follow our social media, and there's a link right there.
And remember, we have a legal clinic coming up on the 16th. You can register for that at the Cedars Union website. We really appreciate everyone coming today. Thank you so much. And we will talk to you all soon. Bye now.
Bye.